But obviously, because there's no questioning of the jurors, one doesn't have very much detail. Well, one doesn't have any detail about that. Individual jurors aren't asked, for example, how long they've been sitting on this. Now, nothing in the evidence is said, and this is important in our submission, about the source of the bribe. The judge may have assumed that the defendants were involved, or some of the defendants were involved, but there is no evidence of the source of the bribe. That it's speculation to suggest that the defendants were, or any particular defendant, perhaps in one sense more importantly, because each defendant obviously has the right to be tried by an independent jury, whether any particular defendant was involved in the bribe. Now, the defence, in contrast to what happened in relation to the second incident, clearly did object to the matter continuing, but obviously what the judge did was remind the jury of their oath. Now, the approach of the Court of Appeal in my submission is
Island Parts and Supplies can get what you need to the islands fast. Need auto supplies? We got it.
5869 paragraph 238 Court of Appeal indicate that there was nothing to be gained from further questioning, and at worst it could have required the discharge of the jury. That's important in my submission because one way we would submit of potentially paraphrasing what the Court of Appeal says is that had there been further investigation, there is reason to believe that what could have come out was further material indicating how a fair trial was impossible because of the attempt at bribery. And that, we submit, if one's looking at the fair-minded bystander approach, cannot be right in our submission, because if there is uncertainty about what will come out, and there is reason to believe that what will come out demonstrates that there is a lack of independence, then the fair-minded bystander would, in our submission, be bound to say, well, in those circumstances, there has to be a real risk that there was bias, because who knows what the answers would have been. They may have been the ones that the Court of Appeal feared. Now, the respondent's answer, in one sense, seems to be primarily that there's no obligation to discharge the jury because anyone could bring a trial to an end then by simply offering bribes. They use the language of win-win. We don't accept that's right for several reasons. Firstly, we would submit, and this is perhaps the most important reason as a matter of principle, each of these defendants had a right to be tried by a jury, and they didn't wait.